introduce Professor Elizabeth Kronk from the University of Kansas School of Law. She has been there for about a year and was previously on the faculties at the University of Montana and at Texas Tech. She is also the director of the KU Tribal, the Tribal Law and Government Center, and she is a citizen of the Sault Ste. Marie tribe of Chippewa Indians and also serves as an appellate judge for the Sault Ste. Marie tribe up in Court of Appeals in Michigan. And her research focuses on the intersection between environmental, natural resources, and tribal law. And oh, I meant to grab your book, which is out front. Another little promotion is that she is the co-author of the case book for Native American natural resources law, and also a recent book, Indigenous Peoples and Climate Change, of which there's a copy out front, and she has co-authored that with Professor Randy O'Day of Florida A&M University School of Law. So we're delighted to have her here, and we look forward to.
Thank you. Well, just thank you so much. It's such a pleasure to be here this morning. I am relatively new to the region and have heard wonderful things about Columbia. So I'm really excited to be here and to see the town, and it's a beautiful campus. So I'm just enjoying my time here, and I'm really excited to be here. Now, this is not the first time I have been the last speaker between you and lunch. So despite Professor Berry's statement, I'm going to try to make up a little bit of time, because if you're like me, your stomach might be rumbling a little bit. So I'm going to go through my presentation and then maybe be available during lunch for questions, so we can try to get to lunch. So I come to these issues from a different perspective. As Professor Berry told you, I am Native American. My research focuses on Indigenous values and Indigenous focus on adaptation. So rather than an ecological or an international environmental law perspective or an environmental perspective on adaptation, I come to this from the Indigenous perspective. So a little bit of a different lens that we're going to look at these issues, and specifically we're going to look at these issues through a lens of climate change. And I really like especially what was being said earlier this morning about viewing these from a more positive perspective rather than the crisis perspective, right? And that's definitely true for us in Indian country, because we are a story of adaptation. Our communities have survived not only many of the past extinctions that Professor Long was telling you about. We have that in our oral traditions. We know that we survived it, but we've also survived other types of stresses such as colonization, termination, and disease. So we have within our own communities the ability to adapt. And the fact that we are here today is a quintessential example of resilience, as Professor Arnold was talking to you at the beginning of the morning. So I really think that Indigenous communities are great examples, and in fact, I just posted on SSRN last night at 1 a.m. An article on tribes as laboratories. You know, we talk in constitutional law about this idea of state as laboratories and what we can learn from the states, but I think that tribes are really great laboratories in learning about adaptation and learning about resiliency. So I'm hopeful that there's some things that we can learn. And towards that end, what I want to talk about is, I'm just going to briefly touch on the impacts of climate change in the Arctic. I think those have already been well covered by some of my earlier colleagues. But then I want to give you some framework for how these issues are arising, so some past legal efforts. We'll look at the Inuit Circumpolar Conference's petition to the Inter-American Commission on Human Rights. We'll also look domestically at Kivalina's petition in the Ninth Circuit. And then, so we don't end on a negative note, we'll look at tribal adaptation and what we're doing in the United States to incorporate some of these theories that you've talked about earlier. Looking at it from a human rights perspective, looking at it from environmental justice, which will build Professor Berry's comments post-lunch, and then also some additional legal considerations. So Professor Arnold was talking earlier about how law can sometimes be a limitation on resilience, and we'll see that when we look at the tribal context. And last but not least, we'll look at what one tribe, or it's actually three tribes, the Confederate Salish and Kootenai tribes, is the Pend Oreille, Salish, and Kootenai tribes, but they're on one reservation, the Flathead Reservation in Montana. You were talking earlier about some of the efforts in Montana. So we'll look at what they're doing in terms of climate change. All right, so really briefly, what's happening in terms of our Indigenous communities? Well, Sheila Cotier, who was the then chair of the Inuit Circumpolar Conference at the time that they submitted their petition to the Inter-American Human Rights Commission, said that our very lifehood is at stake. It is our culture, it is who we are, is at stake because of the impacts of climate change in the Arctic. You may be aware of the fact that the Arctic environment is changing much more rapidly than our environment. Now, us here in this region, I know that KU was closed for 2 days last week because of unprecedented snow and cold. We're certainly experiencing it here. But in the Arctic, it's magnetized 3 times greater. So what are we seeing in the Arctic? We're seeing temperature increases on average of a 7-degree increase. Well, what does that mean? It means that areas that previously have always been covered by permafrost now aren't. And we're having things like tundra fires. Does anybody know what a tundra fire is? I only learned about it recently, but there are these amazing fires that burn underground and can burn for weeks underground and have tremendous impacts on the environment. We're having intense storms, just like we were talking earlier about Katrina, but we're seeing this on a daily basis in the Arctic where so much moisture is building up that these storms are completely destroying our coastline, especially in Alaska. And so, for example, 75% of our Indigenous Native Alaskans live on the coast, and so they're having to literally look at removing their communities to new locations. We're seeing flooding on a massive level. We're seeing changes in animal populations. Caribou are no longer where they were. We talked about the polar bear before. Polar bear are no longer where they were before. Walrus, seals, etc. And why should we care? Well, because when you're legally constrained to a piece of land, when you're an Indigenous population who has a described legal territory, and the animals that you have already subsisted on are no longer there, you either have to make the choice of giving up your legal rights to that territory and pursuing the animals, and now you have the same usufructory rights that other non-Indigenous communities may have, or do you stay there and die and perish? Not easy choices. And so the impacts on humans have been dramatic. So we've seen many of our subsistence hunters have died, falling into thermocars, falling into sea ice, because they've had to go out for longer and longer and further distances. So we're seeing loss of life, we're seeing loss of housing. So many of our Indigenous communities do rely on things like igloos and using the permafrost for food storage, and that's no longer a possibility because of melting and because of increased temperatures. So that is, we talked about the stability and the necessity of food stability. That's a huge issue. Food insecurity in the Arctic, and then of course, as I've already mentioned, relocation. So in the lower 48, we know that climate change is real, we're experiencing it, it's a problem, but in the Arctic, it's literally, we're talking about the loss of entire cultures. So it's just on a tremendous degree scale above. So what are some of our international or Indigenous communities doing about it? The first to really move forward on this was the Inuit Circumpolar Conference. Now they're called the Inuit Circumpolar Council, but I'll refer to them as the conference because that's what they were when they brought their claim. Now the Inuit expand over what are 4 today nation states. So they're in Russia, Greenland, the United States, and Canada. Now they would say that that's their historical homeland. They don't divide or recognize those divisions, but they do fall within the 4 nations. So they petitioned, and when I talk about the Inuit petition, I'm really talking about the Inuit of the United States and Canada because they're going to bring a petition to the Inter-American Human Rights Commission. So that means that it's the Americas, so that's why we focus on Canada and the United States. But they would say that they're all one group. They specifically brought this group to the Inter-American Commission. And the petition was brought against the United States. Now, as Professor Long pointed out, People's Republic of China has since surpassed us in terms of greenhouse gas emissions, but in 2005, when the Inuit brought their claim, the United States was the largest emitter of greenhouse gases. So the argument here is that the United States contributes a substantial portion of the world's greenhouse gases, and it's because of those greenhouse gases that we are getting the climate change effect. Climate change is destroying many of the human rights of the Inuit. So they were uniquely connecting this idea of an environmental challenge, right? An environmental challenge, and connecting it to human rights. So what is so groundbreaking about this Inuit petition is not only is the first time that we see indigenous populations and groups at the national scene bringing forward these climate climate change claims, but they're also uniquely bringing together what are environmental challenges and human rights contexts at the international level. So really a watershed moment. And so basically the argument is that the United States is depriving the Inuit of their human rights, their rights to property, their right to culture, their right to religion, etc. And so we've talked about why it's a watershed moment. Now the Inuit, Sheila Coulter is on the record saying they knew they weren't going to win. They knew they weren't going to win in the sense of winning in front of the commission. To have the commission to say, you, United States, you need to decrease your greenhouse gas emissions because you are destroying the human rights of the Inuit. They knew that was not going to be the result. But what their goal was to get the conversation started, was to get those of us who live below to acknowledge the fact that their human rights are being violated. And in that regard, they were successful. Professor Harvey Sosky at the University of Minnesota did an empirical study following the results of this, and it demonstrated that before they brought their commission, nobody was talking about human rights violations in the Arctic. She couldn't find any incidents. Following that, she found 83 massive, substantial, I think is the term she used, articles regarding this connection, 1 year following the petition. And I've been talking about it for a couple years now, and people were talking about it before I was talking about it. Professor Abate was talking about it as well. So certainly they've gotten the dialogue started. So they've had a win in that regard. So it's kind of interesting in how do we view wins? Do we view them in terms of winning in the court or winning in the public? But they knew they weren't going to win in front of the commission. So what was the response? The complaint to the commission was, I think, 166 pages. And we got back this 2-paragraph response where the commission said that the information provided does not enable us to determine whether the alleged facts would tend to characterize a violation of the rights protected by the American Declaration. So basically there's a nexus problem, right? We have difficulty under the American Declaration to show that the greenhouse gas emissions are leading to these human rights abuses. However, this was a big win. So the Inuit said, okay, fine, but we'd like to hold a hearing talking about the connection between greenhouse gas emissions and human rights abuses. And they got it. And it was really interesting because I talked to Dinah Shelton. And you may know that Dinah Shelton was the first American appointee to the Inter-American Commission. Up until recently, the Inter-American Commission has been dominated by Spanish-speaking countries. And English-speaking and Caribbean countries have not had a large presence there. So Dinah Shelton's appointment to the commission was really a watershed moment for English-speaking countries to have a presence. And she shared the fact that getting this hearing on the connection between climate change and human rights was so incredibly important because it allowed her to then put that into the annual report of the commission acknowledging that a connection existed. So she talked about how as advocates, one of the ways that we can get the ball moving forward is not necessarily to win on a petition, but maybe to have a hearing, that can have really impactful results as well. Interestingly, since this is another side note, since the commission heard this petition, its petitions to the commission have risen to about 2,000 per year, and they can only get through about 70 a year. It's kind of similar to the U.S. Supreme Court in terms of its numbers. So the likelihood that you're going to get the commission to make a final determination on your petition is really low now. So we might want to think creatively as advocates about how we might be able to accomplish our goals otherwise. This raises environmental justice issues, which I'll come back to in a moment. And let's look at what Indigenous communities are doing in terms of domestic litigation. So here in the United States, we have this complaint of the native village of Kivalina versus ExxonMobil Corporation and 32 other private emitters of greenhouse gases. Now, so what is Kivalina? Kivalina is a federally recognized Alaska Native group, approximately 400 people, and they're located north of the Arctic Circle in Alaska. So they're pretty far up there. Oops. Here's a picture. You can see that little A point. It's red over here. The little A point is where Kivalina is located. So you can see they're pretty far up there. And what's happening in Kivalina is massive erosion. So again, because of climate change and because of the intensity of these storms, we're seeing a loss of its shorebed of between 6 to 15 feet per year of their shore. So you can see when you look at these pictures, there's not a lot of shore left between the water and the community. So literally, Kivalina is falling into the sea. And by comparison, you can look at a picture of the community from approximately 1960, and you can see just how much of the community has indeed eroded. This was from 1960, but a lot of that erosion has happened starting in the 1990s. So significant erosion that's threatening the community. This is a list of who our defendants are. Again, a little bit different from the Inuit claim because these are private greenhouse gas emitters. It's really a who's list of your greenhouse gas emitters in the United States. But the argument is that they are emitting greenhouse gases which are threatening Kivalina. So again, emission of greenhouse gases causes climate change. Climate change is destroying Kivalina through these erosions and increased storm intensity, and therefore depriving Kivalina of its property interests. The focus here is the federal common law public nuisance claim is what Kivalina is focusing on. And the argument here, again, is that critical infrastructure is imminently threatened with permanent destruction. If the entire village is not relocated soon, the village will be destroyed. And there's no argument about this. Everybody agrees that the village will be destroyed. The question was not the impact, it was whether or not there was a legal remedy. So the focus here is on the federal common law of public nuisance, arguing that the greenhouse gases constituted a public nuisance. There are other claims as well under state nuisance law, civil conspiracy, and concert of action. Basically, the civil conspiracy and concert of action claims allege that these private emitters were aware that the impact, or are aware of the impact of greenhouse gas emissions, and still continued with their emissions. What happened? The Northern District of California found that it could not adjudicate the claim because it was a political question, saying that climate change and whether or not the United States should have a response to it is best left to either the executive or the legislative branches. Also arguing that there was no Article 3 standing in this particular instance. I've written an article as a law review, or as a law professor, have my law review article saying that was wrong, that the Northern District got that wrong on standing. And ultimately the Ninth Circuit doesn't even talk about either one of those two issues, kind of rejecting the court's analysis, however upholding the court, but the basis is different. The Ninth Circuit says that because of the Supreme Court's decision in AEP versus Connecticut, which held that the federal government is regulating in terms of climate change because it's regulated under the Clean Air Act, that the ability to move forward on a federal common law public nuisance in terms of climate change is no longer viable after that decision. So same result, but different analysis. So what can we take away from all of this? So I told you earlier, this is not a negative story, this is a positive story. So first of all, I look at climate change litigation as a little bit like tobacco litigation. Like right now, we are in the phase of just trying to find the right legal remedy. So we found that the Inter-American Human Rights Commission isn't the right venue. We found that federal public nuisance law is not the right claim. Right now, we have a claim in front of the DC Circuit on atmospheric trust litigation and using the public trust doctrine as a vehicle to bring forward these claims. And many indigenous groups have an amicus brief supporting that effort. So right now we're just kind of trying to figure out what the right legal claim is. So I have hope. I have the new hope, right, of Star Wars Part 4. I'm hopeful. But the goal here, if we think about it, is how as tribal communities, and this is not unique to tribal communities, but how can we minimize and recover from climate change? Now, there are both proactive and reactive strategies. So here in the lower 48, we have the advantage and benefit of being able to focus on those proactive strategies. So we're looking here at anticipating climate change impacts and developing measures to reduce those harms. And we'll look at what the Confederated Salish and Kootenai tribes have done in that context. Now, in the Arctic context, we've largely been looking at reactive strategies. The fact that these communities are losing their land, that they have to be relocated. We're looking at how can we get a monetary benefit or a monetary damage to compensate for this loss of land. Now, some scholars like Rebecca Sosis would say you can't, right? You can't get money to compensate for loss of culture and loss of land. But there are those of us who say, well, you're going to lose the land anyways, so you might as well get some money to help with the relocation. So there is some tension there. But we've talked about largely reactive strategy to this point. So really our options are to resist, to transform, or to move. And so that's where we kind of are in Indian country, looking at those different options. And when you look at these options, you really have to look at them when you're dealing with Indigenous communities through a couple of different ways. So the first is a human rights approach, to be aware of the fact that by virtue of our indigeneity, we have certain human rights. And a good example of that is the United Nations Declaration on the Rights of Indigenous Peoples, which recognize several different rights. And I would argue that some of these rights have risen to the level of customary international law, such as the right to self-determination for Indigenous peoples, because this is not only codified in the UN Declaration on the Rights of Indigenous Peoples, but in several other places. Some of these are not to the level of customary international law, which would bind other nations. They are merely suggestions to the signatory nations. They're not legally binding. But still, when we as advocates look at these issues, I think we need to take them into consideration. So it goes to our right to be distinct political bodies, our right to have our own spiritual and religious traditions, our right to have that connection with the land, and also our right to culture and to the land itself. So you see all of these rights contained in the UN Declaration on the Rights of Indigenous Peoples. Now, when the Declaration was first passed by the UN in 2007, we had 4 countries that did not sign on to it. Any guess what 4 countries those are? Us, yeah.
North Korea.
Oh, I actually don't know about North Korea. But it's the United States, Canada, Australia, and New Zealand, right? The 4 countries, the 4 common law countries with the largest indigenous populations. Since that time, all of those countries have signed on. So the United States signed on in 2010. So it's kind of been an interesting note in how maybe this 4th generation in international law, maybe we're starting to see some changes at the international level. The other thing that you have to take in consideration when you look at these issues from an Indigenous perspective is this idea of environmental justice, which Professor Berry will build upon later. And I think she'll probably cover this, so for the sake of lunch, I will jump over the backgrounds of environmental justice. But the important thing to remember is that tribal communities are environmental justice communities. I think when we talk about environmental justice, we have a tendency to think of other communities, not tribal communities. We have a tendency to think of urban communities, not rural communities. But tribal communities are environmental justice communities by virtue of the fact that we are politically and racially different, and we also suffer environmental pollution disproportionately. And climate change is a classic example of that, right? I mean, the Kivalina and the Inuit have contributed little, if nothing, in terms of greenhouse gas emissions, yet they are the ones who are literally on the tip of the spear in terms of surviving the effects of climate change. So really quintessential examples of environmental justice communities. And anytime you talk about environmental justice in whether it's Indian country here in the United States or it's indigenous communities more broadly, you have to keep certain things in mind. And one of those things is sovereignty. So here in the United States, our tribal nations possess sovereignty. They pre-existed in the United States of America. I always like to tell my Indian law students, next time you're at a cocktail reception, ask people, does the Constitution apply to tribes in Indian country? No. And be like, what? Constitution doesn't apply? And it's because tribes pre-existed. The framers didn't even contemplate trying to apply the Constitution to tribes in that context. And so their sovereignty exists outside of the federal government's sovereignty, and so therefore they have certain rights that other communities within the United States would not. Also, you have to keep into mind this unique connection and status of land. So this really comes up in 2 regards. So the first point, as I've already mentioned, goes back to Professor Arnold's point from earlier, as land as a constraint on resiliency. So it's this idea, I told you that we have this ability to adapt, we have this institutional knowledge, but what's new for us as indigenous peoples is the legal constraints that colonizers have put upon us. So we've now been moved, God bless you, to reservations in different areas, and we've been legally constrained to land. This is new, relatively, in our existence. So these are new limitations that we have to keep in mind, especially as species start to change, and land starts to change, and water starts to change. I was talking to a current 3L here, Mr. Dunn, earlier, and he had worked with the Kickapoo Nation, which is a federally recognized tribe in Kansas. Huge water problems because of the drought in Kansas. So those are all kind of unique issues that we deal with as being legally tied to land. But we also have this spiritual and religious connection to land. So for example, as soon as classes end every summer, I head back to my reservation for summer ceremonies, because it's not about the time when it occurs, it's about the place where it occurs. So I have the spatial connection in my religiousness and spiritualness. So I return to the reservation to participate in those ceremonies. So that is quite unique in many Indigenous communities versus other religions and spirituality where the spatial connection is not as important as the temporal connection. So that's another difference. So the takeaway from this is that when we talk about adaptation, there are certain things which are both pros and cons in terms of Indigenous communities. So we have this traditional ecological knowledge, we have this demonstrated ability to be resilient and to adapt, but yet at the same time we have these limitations and unique legal considerations that we've talked about. So what are some potential tools that tribes can use? I told you again, this is positive, not negative. We can request that as we lose land, the federal government put new land into trust for us, so we have the ability to petition the federal government for new trust lands, and some tribes are moving in that direction, so that's an option. We also can develop our own, under our own inherent tribal sovereignty, tribal environmental law and land use practices to try to conserve and protect that. So we have ability and innovation beyond the federal government. We're not limited to what the federal government or states are doing, and so we can move beyond. The idea, again, of tribes as laboratories. We also can engage in water rights settlements. So, for example, the Crow Nation in Montana, realizing that they no longer had access to the water that they did before, they entered into a water settlement, which was passed by Congress, and we can directly lobby Congress for water settlements. And they got $100 million payout for the loss in water rights, and then they also got their actual water rights quantified. So again, kind of taking money and thinking about new ways that you can address climate change in that regard. We still have state-based claims available to us as demonstrated by the Kivalina example, and also FEMA. So FEMA provides money for adaptation planning, and tribes are allowed to petition for that money as well. So there are options here. This is not all negative. The last thing I want to leave you with is an example of what one tribe is doing, or tribes, because there are 3 tribes on this one reservation. And that's the Confederate Salish and Kootenai tribes located in Montana. Beautiful, beautiful reservation. I think it's the land of the gods. You come over this hill and you see the Mission Mountains, and it's just the most gorgeous thing you've ever seen. And so there's a lot of natural resources that are incredibly important to them. They have a strong connection to the wilderness areas in the mountain. They also have a strong connection to Flathead Lake, which I believe, correct me, those of you who are scientists, but I believe is the largest freshwater lake west of the Mississippi. So they have this beautiful lake that they want to protect. So their environment's really, really important to them. And recognizing that the federal government is failing to regulate on a comprehensive nationwide scale, the tribe has started to look at its climate change adaptation ability. So specifically, they passed a resolution saying that they're going to develop climate change actions specifically to protect the tribe and regulation. They call for, in their resolution, an incorporation of traditional ecological knowledge. So again, building on this, showing this demonstrated ability to adapt as a sign of strength in tribal communities. And what's really great about this strategic plan, if you have a chance to read it, is that these interviews with tribal elders are actually incorporated into the climate change strategic plan. And they talk about what their grandparents did. And what's so cool about these communities, and so different from my community. My community had first contact in the 16th century, so it's not in our institutional knowledge. But they remember first contact. They remember, they know the stories from their grandparents, of their grandparents running into settlers, and it was a lot of Jesuit missionaries coming into the territory. They remember that. That's in their community. And so the fact that they can talk about that and incorporate that knowledge into their climate change plan is really exciting. Also, multiple places, what they do is they divide the community into these 9 sectors, and one of those sectors is culture. And so they specifically talk about, in their climate change adaptation plan, how they're going to protect culture because it's so uniquely important to that community. So what I think is really exciting about the Confederate Salish and Kootenai example is what we, for those of us who live outside of the Flathead Reservation, what we can learn and we can take away from that. So it might be that our communities don't necessarily have Indigenous environmental ecological knowledge, but those of us who've been here, so for example, John was sharing with me that he's from Columbia and his family's from this area, so his family knows this community, right? And that local knowledge could be incorporated as we look into climate change adaptation, just like the Confederated Salish and Kootenai have done. Also looking beyond kind of some traditional sectors towards other things which make human society, like culture, and how we need to protect culture. So I really think that the Confederated Salish and Kootenai and other tribes are not the only ones who are doing this. There are many other tribes who are doing this. Well, there are 8. Of the, might be overselling it there. Of the 566 tribes, we have 8 that have started to do climate change. But that's more than the federal government, right? So I think it really is kind of an exciting time to look at how tribes are building upon their capacity for adaptation and resiliency given these modern legal constraints. So with that, it's a little Valentine's Day chocolate. And if anybody has any questions, I would gladly take them.